But Vashawn, welcome back.
Thank you, Judge.
All right, so Vashawn, you know what I did this weekend? Other than church. So here's the thing. I went to go see Superman.
Okay.
Let me just tell you what my biggest problem is.
Okay.
You put it right here. You said this is where it was, right? It's up here. That movie was awesome.
Sure, I didn't oversell.
Oh no, you couldn't oversell it. And you know what? I will tell you, this is the first Superman that I've ever watched where I can see why. Okay, somebody would say, well, he sort of looks like Superman, but he's not. All of the other ones,
He's so handsome.
yeah, all of the other ones, they keep the hairstyle the same, everything the same. They just give him glasses. But this one, I was like, mm. But you know, I loved reading comics growing up. So I'm telling you right now, give Mr. Terrific his
Yes.
oh my gosh, that guy was so awesome.
So what do you think about the dog?
Okay, at first I wasn't feeling crypto, but at the end, I started feeling him because now you know why he behaves the way he does. Before you just like crypto.
You stayed for both endings.
Yes, I did. But when I at first at the very beginning with crypto, I'm like, crypto, what are you doing?
He is 100% Journey. That's Journey. Their brother and sister.
But no, it was awesome. The next thing I'm going to go ahead and see what Jurassic is doing. You know, you have some movies where you have to see it to the end when they have sort of like Tremors. Did we need the Tremors part 4? No. But I'm going to see Tremors to the end. I'm going to keep going back to that town.
Tremors.
Okay, let me just tell. Oh, here's the thing. If you didn't want to give an Oscar to Tremors, the first one, you could have at least given a nomination to the song that Reba McEntire did. That's a great song.
Just a song, but not. It's like me saying that Attack of the Killer Donuts is an Oscar-winning movie.
Oh, see, now that's just crazy talk. But I will tell you, Big Trouble in Little China. That deserve. The problem is they don't give comedies Oscars. Big Trouble in Little China,
Yeah.
Army of Darkness, the first Tremors. I can watch that over and over again and still laugh throughout. So I don't understand. They need to give people an Oscar. Bruce Campbell should have got an Oscar. All right, who's on the docket? Hello. Hi. So here's the thing. And I know sometimes people don't know this. I was a defense attorney, and I understand that it's hot in San Antonio, but you cannot wear that to court. So, do you have a jacket or anything of that nature? All right. So, what's your name? All right. So, I'm going to show that you were here so you can leave, go to your truck and get a jacket. All right. All right. Thank you. You're welcome. Vashawn, whenever I take my students to tour the jail or the prison, I always get an email about how they should dress. And you know what is the number one thing? Because I always tell my students, don't wear T-straps, don't do that. You'll be surprised. You know what the number one thing they say that they should not wear? Do not wear open-toed shoes because the inmates will go crazy. So I have to tell everybody, you can't wear open-toe shoes. I'm like, put on some tennis. All right, everyone, I'm going to call the docket. When I call the docket, you need to let me know that you are here. Please stand. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. Tiffany Martinez, Matthew Longoria, custody, Clinton Dixon, Arturo Lopez, custody, John Anthony Martinez. Thank you. Ruben Renteria, custody, Lynn Wayne Morin. Thank you. Juan Cruz, custody, Roman Flores, Maverick Ennis, Joseph Alamon, custody, Jason Martinez. Jason Martinez.
Here. Morning.
Good morning.
I'm going to contact my office to find out.
All right, thank you. Julio Michael Hernandez, custody. Procuro Daniel Luna Rodriguez Jr. Procuro, is it Procuro? Procuro Daniel Rodriguez Luna Jr. Devin Berry. Eduardo Rodriguez, custody. Joseph Santos, they're in custody. Okay. Kendall Woodard, custody. DeMonte LaRobert Williams. DeMonte LaRobert Williams. Kaylee Vader, custody. Julio Hernandez, custody. Crystal Veloz, she just left to go get attired. Christina Louise Shad, custody. Shannon Patton, custody. Marcos Antonio Rios. Thank you. Wilfredo Mate, custody. Roman Flores, Ricky Thatcher, custody. Jose Saul Yanes. Thank you. Christine Ann Mount Council, custody. David V. Guerra. Thank you. Baldemaro Joseph Chapa. Baldemaro Joseph Chapa. Ronald Allen, Matthew Anciriaga, custody. Maximiliano Rosales. Yeah. Thank you. Desiree Cook. Desiree Marie Cook. Noah Gonzalez, custody. Ricardo Salas, David Sines, Richard Cantu, Raul Jacob Fernandez, Gloria Carrizales, custody. Fabian Ray Rodriguez, Fabian Ray Rodriguez. Ruben Renteria, custody. Noah Gonzalez, custody. Is there anyone who came in late or your name was not called? What's your name? DeMonte Williams. All right, anyone else came in late or your name was not called? All right, ladies and gentlemen, we're going to be taking our recess at noon. Deputy Laura, I know I say that every time, but I'm getting better. So we're taking it exactly at noon. If you don't see your attorney here, they're probably in another court, but you have the court's permission to step outside and call them on the phone because we're taking our break at noon. And if your business with the court is not completed before then, you're going to have to come back in the afternoon. Does everyone understand? All right, attorneys, you know the court's rules. Please confer. But Sean, I'm telling you, the weekend went by so quickly. And I still have events.
Your hat, sir. Who has the case in here?
Excuse me, who has?
You're going to see somebody like a relative or
Oh, who's in custody?
yes.
All right, so you need to sit on this side. Jason Martinez, Procoro Daniel Rodriguez Luna Jr., Desiree Marie Cook. All right. Okay. Yes. I'm sorry. What is your name? All right. You need to be on the front row. And you say it's Fabian Rodriguez? What page is he on? Let me see the file on Fabian Rodriguez.
That is correct. It's really out.
Do you know what he's trying? Okay.
I know it's in Comal County.
Mhm.
I did not get the type of case. He said it would not be a long one.
Okay. All right. So we'll probably need to recall this.
I did mention that I saw fugitive status, and then the gentleman did not answer today.
Okay.
I don't know the last time Mr. Leal has had contact.
All right, thank you. Deputy Laura, can you check on Fabian Rodriguez to see if there's an issue? Mr. Rodriguez? Fabian Rodriguez? Have you?
It might be a typo. No. I just saw it on our doc.
All right, thank you. Deputy Laura, if you could check on that.
And I believe in speaking with Mr. Leal, I think this case was in the docket last week or something, and defendant did show up. So
yes.
I don't know why the docket is saying that.
Okay, I'm sure there's an issue. Thank you. Fabian Rodriguez? Oh, Deputy Laura? No.
Second row, second chair, sir. Second chair.
All right, who is for the state on David Guerra? All right. So the last time we were here on Mr. Guerra, you were all needed to speak with the complaining witness. Do you know if that has been done?
We will check our notes right now, Judge.
All right, thank you. David Guerra, if you come forward, please, sir. Hello. Your attorney is ill, so they can't make it today.
Oh.
We're gonna we're gonna give you a reset, okay?
Okay.
Miss Ferguson, I need,
I asked him to get the video right, but he never called.
all right,
me.
so here's the thing. We're gonna recall it in 14 days. And then your attorney can be here. And if you feel as though there's something that he hasn't done or you would like to have done, you can discuss it with him. But what I can tell you is normally attorneys, they're in charge of your case. So they know what is good evidence for you and what is not, okay?
He had called me, but I mean, he was supposed to call me.
All right, so what I'm telling you, he's ill.
Okay.
All right.
All right.
Miss Ferguson, I need a 2-week reset. All right, it's gonna be August 4th. Once you sign the reset form, you're excused.
Thank you.
You're welcome. Yes.
You have contact.
All right, thank you. So it's being reset for August 4th. Hmm? Yes, they did. Oh, somebody came and they changed out the filters for the first time ever. You did not want to see those filters. Oh my gosh, those filters were horrible.
I did some Arizona.
Yeah.
So
It's a weird case. I mean, they still really were because like, it's super shady, you know. So they rented Airbnb, they just want to stay over, so just like they only remember me, so they didn't have like an agreement, they didn't know how to lease. He was paying them, and so I guess they had some dispute about, yeah, like he was still paying them. He's like, well, you need to leave. I'm paid up. And I guess they just went back and forth. I said, oh, I just really in trouble. Like he was living there with a husband or whatever. It's kind of a weird deal.
I mean,
It's on my head.
if she has the room in the rent, so you look like it. Totally. But the garage, she's on video.
Yeah, but I think there's some dispute over. So what she said is she just they were so frustrated with them. She said she unplugged. Just like I guess that is something that just filling up in for. But why you deploy else?
Did you have Renteria brought out?
Right.
Thank you.
They didn't have a lease, so they didn't necessarily know. So they get a lease, it's like laid out, so yeah, we're gonna do something. So it's just something kind of change.
Yeah.
Okay, so I'll be independent or be.
And could I see the files on Ruben Renteria, please?
It should have history. Yeah, I would say maybe I could probably do this no like I'm gonna start with all this. I would probably get it done.
Hot.
Honestly. Yes. I think she did it. And only because she doesn't want to keep on back and forth. Yeah. Because she doesn't want to work in soccer stuff. That might get it done.
All right, thank you. And Norma, if you can call Umberto Saldana and have Mac here, please.
No.
All right, who's here on Ricardo Salas?
I am.
And where's Mr. Salas?
He's in custody.
All right, if you'll come down. And are you all ready to proceed on the motion?
Yes and no.
What does that mean?
Okay, well, I'm not ready. I'm not. What I need is, so this is, I just got appointed Mr. Salas, I say, very, very recently. I met him for the first time last week. This is our first set here. He's in a situation where the court only has two options, and one is to do nothing, the other is to put him in prison. And so he's had a lot of family support reach out to me, and I don't have any family members here today. I would like for the court to at least hear from them. And so if the court gave me a brief reset, if you want to set it for a contested, that's fine. We're not going to contest the violations in the motion, but I need a little bit more time to gather his family support so the court can at least hear from him.
All right. So would you like to call it for next week?
It can be called for next week. I'm okay with that. Friday I will be flying out of the country. So
Oh, no, it'll have to be before Friday.
Okay.
And if there's no objection from the state, if his family members want to appear by Zoom, they can as well.
No objection from the state. Thursday would be my best day.
All right, you want to do Thursday this week or Thursday next week?
Thursday next. Good.
All right, Norma, if you'll recall this for July 31st, please. All right, is there anything else, counsel?
No, ma'am.
Do you have any questions, sir? All right, thank you.
Thank you, Judge. Thank you.
You're welcome. All right, who is here on Eduardo Rene Rodriguez?
Mr. Rodriguez is not here.
All right, I think previously there was a motion for a bond forfeiture. Let me check. So are you gearing up for gymnastics season?
Talkable.
Yeah.
That's a source sometimes.
Yeah. Well, sometimes, people need a little break. Even Simone Biles and, hmm. Oh, no, they don't. And, it amazes me a lot of the sports today, it's year round.
Yeah.
And you got to be in this club and go here and go there. Figure skating, everything. I remember back in the day when school was done, you didn't have all these clubs for the summer. You would just practice over the summer on your own if you wanted to.
That's how we did it. So my 9-year-old daughter's at goal.
Mhm.
30 in the morning. I was going till 3:30. Straight to the gym until 8. 14-hour day. Even her mother and dad are working. She's in one day.
Oh, that is insane. I don't know why.
Magically.
It's like, and to me,
I don't know what we're gonna do.
their little bones are building, you know what I mean?
She's strong. She is.
Oh, yeah.
She is.
No, let me just tell you, I've seen the progression from what's been posted
Oh,
from here to now, and I'm like, oh my gosh, she is making. And then when you work out of course, when you're doing your upper bodies, doing your legs and everything, and you have to do the handstand, do the flips and all of that.
well, that problem. All of it. So it's a lot of body weight movement.
Mhm.
It's a lot. She's super strong. I gotta figure this out. Make this one. You gotta get home to 38.
And then still have homework,
Huh.
and then gotta eat.
Gotta shower.
Yeah.
You can't go to bed if you want to. You gotta figure something out. It's just not gonna work. I don't think it's gonna work. Unless you can figure out where to sneak in. So Mr. Rodriguez,
He has a previous bond.
he does. It was a compliance hearing. He's kind of had a history of not knowing about these things. He bonded out yesterday. I was unaware of that, and I did not communicate with him to be here. I don't know if he was told that, but I can tell you that I have not spoken to Eduardo about coming to court today. So we're trying to get him right now, but he has proven very difficult to track down from an office perspective.
Mhm.
I don't expect he'll be here today.
All right, this is what I'm going to do. Because you're unsure if he received notice,
I
right?
don't know. Probably not, knowing the jail, they didn't tell him that, they just spit him out.
All right, so
Go Fernandez.
I'll recall it for tomorrow.
Okay.
And he needs to be here exactly at 9. If he's not here, then a warrant will be issued. State.
Yes.
On Mr. Eduardo Rene Rodriguez, there was a bond forfeiture issued, I'm sorry, judge's warrant issued for him because he didn't show up for a pretrial violation. So they released him from the jail. I guess somebody made his bond, which they should not have made, or the magistrate shouldn't have set a bond for him because I had issued a judge's warrant, but they did. And so defense counsel is telling me he was released this weekend. So he may not know he actually has court date today. So is there any objections to the court recalling it for tomorrow?
No, Judge, not from the state.
All right, so I'm going to recall this for tomorrow and he needs to be here at 9 a.m. All right, thank you.
I have one more, but I'll.
Sure. Which case?
It's Jason Martinez, Judge. He got crossed up with his, court. He'll be here. He's not here, but he will be.
Okay, all right, thank you. Who? All right, I'll take him. Norma LaHood had zoomed in. Can you see if he can zoom back in?
Yes, ma'am.
All right, if you can have that pulled as well. All right, and you can have him brought out. Oh, yeah, this is, yes. All right, thank you. Procoro Daniel Rodriguez Luna Jr. All right, thank you.
Second row, sir. Have a seat on the second row.
Mr. Rodriguez Luna, you need to be on the second row. Jason Martinez. Okay. All right, will you call Mr. Toshi and let him know? Okay. All righty, thank you. Desiree Marie Cook. Joseph Valdemaro Chapa. And what page is Eduardo Rodriguez on? Oh, I found it. Sometimes it is hard to see this docket the way it should be seen. Vashawn, I just received an email from facilities management. So on July 23rd, they're having a workshop on making your home energy efficient. And guess what? They say that there will be energy saving swag given. You know that movie, You Had Me at Hello? You had me at energy saving swag. So we're going to see. Last time I did that, they had some energy saving light bulbs. It was awesome. Marcos Antonio Rios.
Present, Your Honor.
Hello.
Good morning, Judge.
Good morning.
Got two things for you. Today is our very first sitting on Mr. Rios. Additionally, I do have an agreed motion. The same thing you have in your hand. For to convert the GPS tracking only so you can be allowed to work.
All right, we're going to call 2025 CR 007192 State versus Marcos Antonio Rios. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Michael DeLeon for Mr. Rios.
And are you Mr. Rios?
Yes, ma'am.
All right, so the first thing we'll take up is this motion. Defense has filed a motion requesting that conditions of bond be amended. State, have you had a chance to review the motion?
We have, Your Honor, and we've spoken with the family, and we are in agreement with defendant's motion to change it to tracking only and add a no contact order with any minor child.
We're agreeable with that.
All right, so you understand if you go to do any type of work in any type of home, that, let's go off the record for a moment. To make sure that things are crafted so everyone is protected, okay? All right, thank you. Oh, Michael, do y'all want to write it on here? This is the one I have.
Okay.
And we'll make sure we're done by then. Okay. Great, thank you. Yes. Good morning. Hi, just give me one moment. Hi, okay.
In here?
Hey, just let me all know when you're all ready on Marcos Rios.
Yes, Judge. About to come back up.
Thank you. All right, who is here on Ronald Lamar Allen?
Yes, Judge. Charles Busher here.
All right, if you have your client come up, have you confirmed with the state?
I have. It's
Mr. Allen?
Yes.
So the court is calling, oh, counsel, Deputy Lawyer, can you move into the other end? We're about to take up a hearing. Court is calling 2025 CR 007563 State versus Ronald Lamar Allen. Can I have parties announced?
Megan Galloway for the state.
Charles Butcher for the accused.
And are you Ronald Lamar Allen?
I am.
Right, so before we take up any settings or discovery issues, counsel, you filed a motion requesting a reduction of bond.
That's correct, Judge.
All right, and what is the bond currently set at?
The bond is currently set at $100,000.
And state, are you in agreement to reduction?
No, Your Honor.
All right. And state, are you prepared to proceed on the motion?
Yes, Your Honor.
All right, defense, it is your motion. Do you have any witnesses?
Yes, Judge. I have Miss Evelyn Allen is here. She's the mother of the accused.
All right, Miss Allen, if you'll come forward, please, and sir, if you'll stand near that computer. Yes. Can you raise your right hand for me, please? Do you solemnly swear upon the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. I need to make sure you keep your voice up because one, I need to hear you, and also the court reporter needs to hear you. Cindy, do you need her to wear the little microphone or no?
No, she's in front of the mic.
All right, if you'll state your name for the record, please.
Evelyn Allen.
All right, that's the right tone for me to hear. Thank you. All right, defense, you may proceed.
Miss Allen, are you the mother of Ronald Lamar Allen?
Yes, I am.
And how long has Ronald lived in Bexar County?
Over 8 years for sure.
And for the court, would you describe your relationship with your son?
We're very close. He lives with me, so he does help out around the house quite a bit. Like yard work, grocery shopping. We have a close relationship as far as sharing.
Now, Miss Allen, are you aware of any past instances where Ronald has failed to appear for the court?
No, not at all.
And under the circumstances of his custody battle, he's had to be in court a lot of times. Is that right?
Oh, yes.
And how long has his custody case been going on with the ex-wife or his ex-girlfriend?
Well, the trial is 8, so I would say close to 8 years old.
Now, are you aware of any past instances where Ronald has attempted to flee the jurisdiction or avoid any court proceedings?
No.
And if Ronald were released on a reduced bond, would he have a place to stay?
Yes.
And would you be willing to supervise or help monitor him if it was required by Judge Boyd?
Yes.
And can you describe any of Ronald's involvement in his family or community prior to this arrest?
Ronnie is very light. In fact, one of the neighbors is here with us today that he's helped out. She's had health issues and he would bring her hot meals, take care of her yard. We in an elderly neighborhood. He's helped the elderly clean their gutter if they need to move heavy flower pots, whatever. He was well liked by all the neighbors in the neighborhood.
Now, Miss Allen, have you ever made any efforts to post Ronald's bond?
I've made several attempts. I've called about 5 bondsmen, and each one had different regular stipulations. Once was like I needed 4 signatures, co-signers, they called them, that had to have employment and live in Bexar County, that would be responsible if in the event he would skip out for the $100,000. Plus a collateral of putting my home for collateral. And then another one required, I think, co-signers other than me, two co-signers, but other than myself or my husband at the time, being a piece.
Now,
And and collateral, whether it be like any my home or with 100,000. And I think the bond, they started at 10,000, but said it could be up to the discretion of the manager of the bonds company. It could be more, but not less.
Now, Miss Allen, do you believe a lower bond would allow your family to safely and responsibly secure the release of Mr. Allen, of your son?
It would be affordable, yes.
And what financial resources have you exhausted trying to help Ronald?
I'm embarrassed to say, but I've limited out all my credit cards and all my credit. Thank you. And now that my husband's gone, that income is ceased. So it's it's very stressful and trying to find funds to.
Can you tell the court about your late husband, Ronald Wayne Allen?
Glad to. We were married in April for 52 years. We went to high school together. We had our class reunion, 55-year class reunion in September, which I'm glad we got to share that. And our anniversary, we're from Louisiana, so we got to share crawfish. And I'd like to say that for his final days, he enjoyed that, but it was a shock that he passed.
When did your husband pass away, Miss Allen?
June 13th.
And this was while your son was in the jail?
Yes.
And how did Ronald respond to the loss of his father while he was in jail?
Very stressful, very anxious. He just wanted to give me a hug and support, be with the family. At first, I don't think he realized that he had passed because I couldn't tell him. And I don't think reality set in now. He's very, very, it's stressful. He says that he thinks of him a lot, trying to sleep, and that just needs to give me a big hug.
Miss Allen, has Ronald been able to attend any funeral services or grieve properly regarding your husband?
Your Honor, because I have two boys and myself. We're waiting for Ronnie to be able to attend the services before we can schedule them. We're from Louisiana, so our main service would be in Louisiana, Lafayette, Louisiana.
Miss Allen, from what you've observed, does Ronald struggle with any mental health concerns?
Very anxious, very stressful. The stress being in prison, has jail, how they call it.
And has he ever had any mental health conditions? Has he ever suffered from schizophrenia, bipolar disorder, or anything like that?
No.
And do you believe that Ronald would benefit from counseling or evaluation if released?
Oh, absolutely. He and I both to be able to grieve, learn how to grieve together and get beyond this because we need closure and we need to share that bond. It's very hard for me all alone at the house.
Now, Miss Allen, regarding these underlying charges, have you ever seen your son engage in anything violent or have any violent offenses, or has he ever lashed out at you in any way?
No.
And regarding these underlying charges, maybe you can tell the court a little bit about what these charges have meant to you substantially.
Trying to understand the charges. At first, I said, this doesn't sound like my son. But again, he can get excited. He can get anxious. He was struggling with the custody and the process that was going on. And he can get excited and we're from Louisiana, so he may raise his voice, but as far as he wouldn't even hurt himself. I mean, he's very, very controlled person. He's very low key. I've never seen him ever say anything to harm anyone. And much, and I'm going to bring in the custody was for his child that he loves very much. He's a very good father. They've always enjoyed very good times together. And so this was very trying and distressful for him. And trying to communicate with him about the loss of his dad and my grief, it's hard on the privacy of a phone for minutes at a time.
Miss Allen, I want to thank you for your testimony and again, I'm sorry for your loss regarding all of this and the stress that you've been under the last 90 days while he's been in jail. I'd like to pass the witness now, Judge.
Any questions?
Miss Allen, just briefly, I have a couple of questions for you. I said just briefly, I have a couple of questions for you, okay?
Okay.
You stated that your son moved to Bexar County about 8 years ago.
Yes. I mean, he's been in Bexar County as long as his child's been born.
Okay. Do you know where he was living before that?
I can't. When they were married, they lived in Wimberley.
Okay, Wimberley, Texas.
Yes.
And then before that, did he live in Louisiana with you and your husband?
I've been in Texas for 52 years.
Okay. So at any point did your son live in Louisiana or
no? He may have stayed there to help a family member. His grandmother had eye surgery at one point, and his uncle lived, well, that's Texas, so just with his grandmother years and years. I mean, maybe 30 years ago, but when she had, but he never had a residence.
Okay.
He was
just
helping caregiver.
Okay.
Yeah.
All right. Thank you. And then are you currently working right now or are you retired?
I'm retired.
Okay. How long have you been retired?
21 years.
Okay. Do you receive like retirement from the government?
No.
Okay. Do you have like a 401k or any retirement from your job?
I have a retirement, but I don't survive on it.
Okay.
I survive on Social Security.
So about how much income do you get monthly?
I don't remember, but I think it's like $1,500 or $1,600 a month.
And before your son's arrest, was he employed? Okay, what was he doing for work?
He was like what I understand, a courier, like delivery.
Okay. Was he employed with like a company or self-employed? Do you know?
I think he mentioned I didn't get too much into his business, but like a self-contract or contract.
Okay. And do you know what his like hourly rate was or monthly rate?
No, I didn't get into that.
Okay. Do you know if he has any savings accounts?
I can't answer. I don't know.
Okay. You guys haven't discussed that in your efforts to make his bond? If he has money saved up to assist you?
When we talk on the phone in the prison, we try to keep everything generic for the privacy, and not get into financials to keep it private. So if
okay. But you would agree with me if he had some type of money or savings that would help you try to make his bond, right? That would assist you in your efforts. Yeah. And then as far as your home, you said you've lived here for 52 years. So do you own your home currently or are you renting? You own it? Okay, and do you have a vehicle that you own?
Yes.
Okay, and what about your son? Did he have a vehicle that he owns?
No.
No? And what about a home? Did he have a home that he owned prior to this?
No.
Um, are you aware of any of your son's prior arrests?
When he had his divorce.
Okay. Would that be around 2015? Have you heard that he was arrested for assault, family house, impeding breath or circulation?
Is that again? I'm sorry.
Were you aware that in 2015 he was arrested for a family violence assault, including strangulation?
I was aware that he had a legal issue with his divorce. Yeah.
Okay. And then before that, in the year 2000, were you aware that he was arrested for possession of marijuana between 5 pounds and 10 pounds?
I believe that I had not.
You did? Okay. And then were you aware that in the year 2016 or 2015 that he was arrested for unlawful restraint? In 2015. Okay. And were you aware that in 2016 he was arrested for assault, bodily injury against a family member?
In what year?
2016.
No.
We pass the witness, Your Honor.
Any further questions?
Yes, I'll take short redirect. So, Ms. Allen, you are aware that your son has had some violent instances, allegations. Where were these allegations regarding the family violence assault coming from? Like, who do you think is actually made these allegations against your son, Ronald?
The one that I said I was aware of would be the ex-wife.
And have any of these allegations and any of these charges in the past, have they resulted in Ronald going to jail or having a conviction?
Not that I'm aware of, no.
So he's never been in jail for this long for any of these alleged assaults from the past?
No.
And most of these are from over 10 years ago or at least 10 years ago?
Yes.
And on the marijuana charge, that was in 2000, in the year 2000. He was a young man at that time, right?
Many years ago, yes.
And you were aware of that?
Yes.
In light of all of these items and these matters, has Ronald ever been violent towards you?
No.
Do you have an ability to supervise Ronald if he's released on bond and put under your supervision?
No.
All I have, Your Honor, regarding this witness.
All right, any further questions?
No, Judge.
Any objections to the court asking a question?
No, Judge.
All right. So in your home, are there any weapons? No guns?
No, ma'am.
And if your son were to make bond, he would be staying with you?
Yes, ma'am.
And is that in Bexar County?
Yes, ma'am.
All right. Any other questions from either side?
No, Judge.
Any other
No, Judge.
questions of this witness? I'm sorry for your loss. It is so rare to see people who are high school sweethearts get married and that it lasts for that length of time. All right. Thank you so much for coming in.
Thank you very much.
You're welcome. All right. Call your next witness.
That's the only witness I have for today, Your Honor.
All right. State any witnesses.
No witnesses, but the state would offer states exhibits A and B for the purposes of this hearing, which is a copy of the prosecution guide and the criminal history of the defendant.
Any objections to the court reviewing?
No objections to that.
Okay, just give me a moment to review. Counsel. All right, the court will hear argument.
Judge, in addition to all of this, I do have a copy of Ronald's father, Ronald Wayne Allen's death certificate, so that we know that this is an honest
Oh, no,
regarding this man. He was an Army veteran, and
all right, and I reviewed the document, and counsel, you're an officer of the court.
all right, thank you,
Thank
Judge. Regarding this matter, Your Honor, we're here today on this motion to reduce bond filed on behalf of Ronald Allen. Mr. Allen is currently sitting in the custody under conditions that neither reflect his flight risk nor serve the purpose of public safety. We think that this incarceration, in fact, functions as an instrument of oppression prohibited under the Texas laws and the United States Constitution. Under the Article 17.15 of the Code of Criminal Procedure, the court must consider the following factors. The bond must be sufficiently high to ensure appearance. It may not be used as an instrument of oppression. The nature and circumstances of the offense must be considered. The accused's ability to make bail must be regarded, and the future safety of the community and any alleged victim must be weighed. Further, Article 1.07 guarantees that bail is a right, and Article 17.09 permits this court to modify bail at any time prior to his conviction. The Eighth Amendment of the U.S. Constitution prohibits excessive bail, and the 14th Amendment's due process clause requires this court to avoid pretrial detention solely on the basis of poverty. The application to this case is that there's been no physical confrontation and no victim impact regarding this case. The underlying facts of the case would show that Mr. Allen was in a private conference with his custody lawyer at the time of the alleged offense. We want the court to understand that this was an emotionally charged conversation because of a long custody and visitation battle with his ex-wife. And his family attorney had only been retained for several weeks. The statement that he made that gave rise to the terroristic threat charge was made outside the presence of any alleged victim, and there is no indication that Mr. Allen took action to carry out any of his threat. The case was documented by the San Antonio Police Department and the Fusion Center, but it resulted only in an information report, not an arrest at the time. No firearm, no plan, no attempt, just words spoken in the distress amid his ongoing family court litigation and the emotional duress. Notably, the complainant himself, the attorney that he had, called the SAPD out of an abundance of caution, but he was not in fear. The compelling personal circumstances on this case are substantial because of in addition to the low risk nature of the alleged offense, Mr. Allen has experienced profound personal hardship because his father, Ronald Wayne Allen, passed away while Mr. Allen was incarcerated. He has been unable to grieve properly or to attend final arrangements. Family tragedy only worsens the financial burden of a high bond. We think that Mr. Allen needs help to grieve, to deal with these charges. It would also help for him to be able to manage his defense. You heard today from Evelyn Allen. She's the defendant's mother. She's a woman of modest means who has established her financial resources through her marriage with her husband, who recently passed. She's exhausting her financial resources trying to help her son, and she has testified that Mr. Allen has longstanding ties with the community, has never failed to appear for court, and she is willing to supervise him personally, and that the current bond amount is financially oppressive to their family. Your Honor, we are not asking the court to ignore the concerns of public safety, only to apply the law fairly. There's been no evidence that Mr. Allen poses a threat to any person if released. He does maintain there is a civil protective order between him and his prior lawyer because he's the one that made the report and the outcry regarding the terroristic threat. But he would abide by that protective order substantially. There is, however, evidence that the current bond amount is far beyond his means and his family's means, and we believe that it's unnecessary to secure his return to court. We're requesting at this time that the court consider reducing Mr. Allen's bond to a reasonable amount or releasing him on appropriate pretrial conditions, which may include GPS monitoring, counseling, or any mental health evaluation if the court deems such conditions necessary. We believe that this would align with the Code of Criminal Procedure, Article 17.15, as well as the constitutional safeguards designed to protect the rights of the accused while preserving public safety. From where I'm sitting, I recently became his second criminal defense lawyer, and it is a difficulty for me to prepare for a complicated, what's likely a complicated trial regarding this case. I've filed motions to suppress and a motion to dismiss this charge, but I'm not here on that today. I'd like to get my client released under a reasonable bond so that I can prepare and have him prepared for those hearings outside of the jail.
All right, State.
Judge, we believe that the bond has been set in a sufficient amount regarding public safety. Regarding the testimony that you heard from today, it sounds like, well, the mother does have limited needs. She does have several items of collateral available to her, and there's also this untapped resource and the defendant's own personal belongings, financial resources, and bank accounts that they've neglected to speak about for privacy reasons, as testified to by her. And then regarding just the flight risk, I mean, he does have ties to locally Texas and Louisiana, so we would ask that you keep the bond amount at 100,000.
Judge, I guess if I may, with respect to the family resources, they are. She doesn't have a lot of access to a lot of the funds that might be available in their normal circumstances if Ronald's father was alive. Just weeks after Ronald was incarcerated or jailed, this man died. And so we believe, and Ms. Allen has advised me, that a number of those resources and properties are going to be tied up in probate in the coming weeks.
Well, let me just explain something. I don't believe that someone should be required to put their home up for collateral to make somebody else's bond. So I'll just lay that there. That is gambling to put your home up. Yes. Because the bondsman will take your mother's home if you fail to appear. Mm-hmm. So this is the court's issue. So I've read defense, I've read your motion. And in your motion, you put that Judge Hortek found that your client wasn't a threat to his son or the community at large, and that there will be a protective order regarding his ex-wife.
Yes, there is, Judge.
And that he will be allowed to proceed with his visitation rights. So I don't understand. On the civil side, they said he was going to have his visitation rights. It's going to be supervised, and they wanted a psychological evaluation. I don't understand how we go from that to now he's before me on a charge of terroristic threat. And Mr. Allen, I want you to know I don't take any of this as true because I haven't heard any evidence on the facts. The reason why I bring that up is because, as you stated, counsel, part of the things I consider in a bond reduction is safety of the community. So in this case, safety of the community would be based upon the indictment, the community at large, and also the protective order that your ex-wife has, her safety as an individual, but then the community at large, based upon the exhibits that the state had me read, which was part of the police reports. So that's the court's concern.
Well, Judge,
and has he done a psychological evaluation? Has that been done, or was that completed?
No, Judge. The order coming from the civil case, from my understanding. I'm not a civil lawyer,
Mhm.
but my understanding is that that final order in that Sapser modification that was filed by the ex-wife and was litigated while he was in jail through Judge Fortick, that is pending as far as the order being signed.
Okay.
There are judge's notes that indicate what I mentioned in my motion, that the protective order against the son was denied. There is, I think there's other ways to secure the community other than a $100,000 bond. I think a GPS or any kind of tracking would be able to secure compliance. And if there's a bond condition that prohibits his contact with either the complaining witness in the underlying terroristic threat case, or who I believe did get his own protective order, and then also a protective order, or rather a bond condition that prohibits his contact with the ex-wife, and ask him to remain in the jurisdiction. I think that can mitigate some of the risks of him not coming to court.
All right. And state?
I would just reiterate my prior arguments and then the testimony regarding his prior arrest.
All right, this is what the court is going to do. With regards to your other motions that you filed, the motion to dismiss and the motion to suppress, we'll set those for hearings and y'all confer. And I would like those hearings set as quickly as possible because that may end up addressing whatever issues are here. But Mr. Allen, I'm going to deny the motion to reduce bond. I'm going to order that there be partial GPS for employment only. GPS fees will be waived, and there will be a referral to Center for Healthcare Services. So if y'all would confer with Ms. Ferguson on having that motion to suppress heard counsel and also your motion to dismiss. And so if y'all speak to her, she'll tell me what's the date that y'all both can agree on, and we'll make sure that hearing is heard.
Thank you, Judge.
All right, you're welcome. Thank you, counsel. And just come back to me once you get a date. Yes. State. Megan?
Yes.
Norma is telling me that his next court date is July 28th. Would you all be ready?
Because I haven't had an opportunity to reach out to the witnesses, I can't say for sure, but I'll do my best to have everyone ready.
All right, so counsel, if the state needs to have witnesses by Zoom, are you okay with witnesses appearing by Zoom, or you want them all in person?
I don't have any objections to witnesses appearing by Zoom.
All right, so defense said if need be, some can appear by Zoom. All right, so we'll put you down for next week, Mr. Allen, and if the state is able to have their witnesses sooner than Monday, they'll let defense counsel know, and we'll have you brought over sooner, all right?
Okay.
All right, thank you, sir.
Thank you, Judge.
You're welcome. All right, Mark LaHood. All right, could I see Mr. Renteria, please? If you'll come down. Hello.
Oh, good morning.
Good morning. All right, so your attorney is still in legislative session. I guess they've had a special session or they extended it. So this is going to be recalled. Norma, recall this for August 11th. All right, thank you.
Still here? Okay.
Marcos, Antonio Rios, are y'all ready?
Yes, Judge.
All right, we're going to go back on the record in 2025 CR 007192. State versus Marco Antonio Rios. Could I have parties announced?
Rick Pena for the state of Texas.
Michael DeLeon for Mr. Rios. Judge, we've discovered Mr. Rios has been a plumber for 8 years. He does mostly commercial work. Very rare that he ever does residential, but we put a provision in there which will hopefully take care of any concerns the court might have.
All right, so the agreement that you all have reached does address the concerns of the court. So it will be GPS tracking as agreed to by the state. There's to be no contact with any minor child, and there's to be a co-worker present with you if you're in any residence. And a supervisor will send notice that this order has been followed every week to pretrial services. Do you understand?
I understand.
So what that means is if you're working in a residence and for some reason, because I know with plumbers, sometimes someone will have to go to the truck to get a tool or something of that nature, you're going to need to be the person to go get a tool from the truck. Otherwise, you need to accompany them to get whatever tools. Do you understand?
I understand.
All right. Now, the next thing we need to address, council, I have signed that motion.
Judge, our very first appearance. I reviewed the state's file. There's going to be some discovery I need to look into, including their CPS records on a CD and some additional same records and, of course, the counseling recording.
All right. State, do you have the CPS records in your custody?
It should be right there in the.
It appears we might, so we probably just need to burn a copy for us.
All right. All right, Norma, I need a 45-day reset for discovery, please.
Judge was supposed to be in Live Oak County on September 11th.
All right. That's not a good date for council.
Yeah, I'm supposed to be in Atascosa County on the 9th. Yes. I can do September 8th.
All right, we'll have you back on September 8th. And council, I'll put this in the system. And then you'll need to make a copy of the order if you need a copy of the order.
Okay, Judge, sounds good.
All right. Just give me one moment. And thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
I appreciate that, Your Honor.
You're welcome.
Thank you, Judge.
All right, Matthew and Sariaga. All right.
Good.
Good morning. How are you doing?
Good. How you doing?
Oh, I'm doing okay. So have you conferred with the state?
I have not, Judge. He was magistrated and no bond was ever set.
All right. If you want to speak to the state on an amount of bond, and then I'll bring you all back up.
Okay, yes, ma'am.
All right. Thank you. Crystal Veloz. All right. This is a long indictment.
It is. It has actual checks in it.
Yes.
Federal.
All right. So where are we on discovery?
So I just learned about some additional discovery that the state has. This is essentially a white collar case.
Mhm.
There's a lot of discovery to go through. Additionally, it's essentially a restitution case. So my client is going to try to get as much money together as he can in hopes of achieving a more reasonable offer from the state. So I'd like to ask the court for maybe a longer reset.
All right. Ms. Ferguson, if you can set this for a 45-day reset for discovery.
September 8th would work. You wouldn't give me a little bit longer than 2 months?
No. All right. So September 8th or 11th, counsel?
8th.
All right. We'll come back on the 8th for discovery. State you'll need to make sure that they have all of the discovery.
Absolutely, Judge.
All right. Thank you. Thank you. Once you sign the reset form, you're excused.
Thanks.
Jason Martinez. Hello.
Good morning.
Good morning.
No.
All right. Let me find you on the docket. Thank you. All right. So counsel, where are we on discovery?
I think we're good on discovery, Judge.
Okay. Was state able to tender an offer?
They are, Judge. We're going to be submitting an application this week, probably today, for a pretrial release. I anticipate it will likely get approved. So just kind of let you know where we're going.
All right, Ms. Ferguson, can I have a PTD date, please? All right, so this is going to be August 19th.
August 19th.
All right, so I allowed your counsel to have some time to make sure that you show up, but court is at 9 a.m., all right? All right, and I don't want you to answer me, but if you're drug tested today, is everything going to be okay? I have a feeling I know what the answer will be. So for his conditions of bond, does he have any conditions?
I admittedly do not know the answer to that.
All right.
Probably
not.
Well,
it's probably not based upon the case. So are you employed?
right now, no.
All right. So you need to start looking for employment. You understand?
I'm already in
All
the
right.
market right now.
Okay. How old are you?
Me, 22.
All right. Do you live with someone?
Yeah, I live with my mom. Well, in the beginning of the year, I didn't have a job because I broke my foot in the beginning of the year.
How did you break your foot?
Work.
Oh, so at the beginning of the year, what type of work were you doing?
Construction, like site work, like heavy machinery and stuff.
Oh. Well, who knows? Maybe you need to speak to an attorney.
He was playing for the Spurs, yeah.
Okay, I like that. But see, now I'm about to ask him the $1 million question. What position were you playing for the Spurs?
It was Planet Center.
I like
What's
that.
that small guard, but both of them were, no, I'm sorry.
All right, so I'm gonna add an addition to his bond. And I'm gonna require that he do sober support meetings. And so you're gonna have to do 30 of those in 30 days. And it's to make sure that you maintain sobriety, you understand? And your attorney will explain to you what that is. And we will see you back on the 19th.
August 19th.
Yes.
Thank you.
Yes, you're welcome.
Thank you, Judge.
Thank you. Oh, is the Mac, are you ready on Mr. Saldana's client? Hi.
Mr. Gonzalez informed me that he was told by one of his family friends that his attorney that he might appear before 11. So I'm gonna, if we can, just I'll wait.
All right.
In gallery for 30 minutes.
All right, thank you. All right, thank you. All right, are y'all ready on Matthew and Siriaga?
They stepped out the hallway.
Okay. All right. Haley Joe Vatter. Good morning. Hello.
Hello, ma'am.
How are you doing today?
I'm doing all right. How about you?
Oh, I'm doing great. I cannot complain. All right, so on this case, counsel, do you have all discovery?
I have a request pending, Judge, but I
Yes.
haven't received everything yet. And then I think we're still pending some discovery because the state wants to reach out to CW for receipts for restitution.
Okay.
She has this indicted case and then a pre-indicted case, so the state wanted more time to reach out to both victims.
Judge, and just so the court is aware, she does have an unindicted case that I'm reaching out to tender a global offer to defense.
All right. So when would you all like this case recalled? How much time does everyone need?
The state told me they would be okay with maybe 2 weeks.
All right, Miss Ferguson, if you can recall this for 2 weeks. And Miss, has your client had any type of mental health issues?
I believe so.
All right, is there going to be any issue with that or competency? She's like, no.
I'm not entirely sure.
I am also not entirely sure, but I'm going to do another jail visit with her to review her discovery with her.
Okay.
And then I think after that, I will be able to proceed either way.
All right. All right, what date? And who is Leo?
That would actually be a zodiac sign, ma'am, and that
That's what I was thinking.
about 5 of my family members.
Okay.
My daughter, my son, my brother, well, he's not a family member, a close friend, and my nephew.
Okay. All righty then. All right. So we're going to see you back on August 4th. And if anybody wants you brought back sooner, they will let the court know. All right. Do you have any questions for me?
I don't believe so.
All right. Thank you.
Thank you.
Do you need a cough drop?
Okay, thank you.
All right. Thanks. Who is here on Procuro Daniel Rodriguez Luna Jr.?
President, Your Honor. I don't think we need to prosecute on this case.
Come forward. All right. So, sir, you need to be here at 9 a.m. right?
What date? No, no.
9 a.m. for
Oh,
court.
thinking about today.
If you're not here at 9 a.m., you're late and a warrant may be issued. You understand? All right. So where are we on his
I
PTD?
just got him to sign it, Your Honor. I'll submit it to them. They accept it pretty fast.
All right. So why is it just being done today? Because we were here on June 13th for a PTD.
I had trouble communicating with my client and also outside of town on some of those days.
All right. So that needs to be filed today.
I'll do it today, Your Honor, and if you want, we can recall it for next week if you want. They're pretty fast at accepting it.
All right, Miss Ferguson, I need a date for PTD. And do this one quicker than normal. Set this one sooner than normal. All right, so we will be back on August 4th. Once you sign the reset form, you will be excused. Thank you. If you'll just have a seat, your attorney will bring the reset form to you, sir. All right, and Devin Berry, you need to call your attorney. You need to call your attorney for your attorney to be here. Thank you. David Signs. Hello. Are you ready to proceed with the motion?
No, Your Honor, it's going to be a contested motion.
Oh, let's see here. All right. So state, will you prepared in 14 days for a contested?
We will be, yes, Judge.
All right, Ms. Ferguson, I need a 14-day reset for a contested hearing. And it is on David Signs. Hello, sorry. August 4th. All right, we'll see you then.
Thank you, Your Honor.
You're welcome. Bashan Signs is set for a contested hearing on August 4th.
Yeah.
Could I see the file back on Mr.
Hi.
The file back on Michael DeLeon's client, please. Thank you. Because something was put in Odyssey that's not correct. Yes. Thank you. No, yeah, that's not the correct file. Let me see which one it was. Just 1 second. I need Marcos Rios.
Sorry.
That's okay. That's fine. And Mr. Woodard, just let me know whenever you're ready and I'll fast track you. Thank you. Who's here on Jose Yanes?
Butcher for the defendant.
All right, Mr. Yanes, if you'll come forward. All right, have you conferred with the state?
Yes, Judge, I did.
Let me just find him on the docket. Thank you. All right, counsel on Mr. Yanes, do you have all discovery?
I don't have all the discovery, Judge.
All right, what is missing?
I'm missing a video, and I think it's just a download problem that I have because it's substantial amount. I just came onto this case and it was set for an arraignment today. This is his first arraignment. He's made bond. I conferred with the state and they have made some offer, but we want to review the discovery. And the state has told me that they're not opposed to a short reset so that I can.
All right, state.
Yes.
Defense counsel is saying there's an issue with the download on the video because I guess it's too large. Has that been addressed or how is that going to be addressed?
But need to bring me some type of drive and we got.
Sure.
All right, Ms. Ferguson. If I can have a reset date for 30 days for discovery. So between now and then, you'll need to provide the disc.
Yes, Judge, I recognize it's an old case. It's from 2022.
Okay.
I want to get it resolved too, but here we are.
All right, what date? I guess August 19th would be your discovery date. All right, thank you for addressing appropriately for court. Just have a seat. Once you sign the reset form, you'll be excused and counsel, you get your reset form. Thank you.
Sorry,
All right, if you'll come up, please. Thank you for your patience, Mr. Woodard, although you're always patient. I appreciate that.
No worries, Judge.
All right. Court is calling 2025 CR 00792 State versus Matthew Insuriaga. Could I have parties announced for the record, please?
Ashley Jones for the state.
David Andre Wood from Matthew.
And are you Mr. Insuriaga?
Yes, ma'am.
Insuriaga.
Insuriaga.
All right. All right. Defense has filed a motion asking that a bond be set. According to law, he's entitled to a bond. The only issue will be what the bond will be set at.
Yes, ma'am.
All right. Have parties had a chance to confer on a bond amount?
We have, Your Honor.
Is there any agreement?
Yes, Madam Judge.
All right. Defense, do you have any witnesses?
No, Your Honor.
All right. Then the court will hear arguments. State unless you have witnesses.
We do not, Your Honor. If the court would like, if you can give me one moment, I will print out the prosecution guide for you.
All right. And for the record, the court is aware of the charges. And defense, what bond amount are you requesting?
$50,000, sir. EPS with partial house arrest.
And state, what bond amount are you asking for?
The state is asking for 100,000 full house arrest GPS and a no contact order with the complainant or any minor child. And the state would also like to enter an exhibit. If you're going to work, it's exhibit 1.
All right. While the state is doing that, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Make sure you speak up so the court reporter can hear and I can hear. If you'll state your name for the record.
Matthew Insuriaga.
All right, so the questions I'm going to be asking you are questions related to bond conditions. So I'm not going to ask you about any facts of this case. Do you understand? All right, number one, if you are able to make bond, who would you be living with?
A close friend of mine.
All right. And this close friend of yours, do they live in Bexar County?
Yes, ma'am.
Are there any minors in that household?
Yes, ma'am.
That's not going to be allowed. So do you have any other place to stay?
Yes, I was just had to talk to I need to talk to you.
So what I can tell you is I'm not going to allow you to reside in any household where there are minors. I don't take these allegations as true because that's not what we're here for today. It's just a matter of setting bond. And as in setting bond, I have to make sure that the community is protected. Do you understand? So, do you have any employment before you were taken into custody?
No, ma'am.
All right. Have you ever in the past used any type of drugs or alcohol?
No, ma'am.
No marijuana, nothing?
I just smoked like a year or two ago. That's about it.
All right. So when I ask these questions, I need to know the full picture. All right.
Yes, ma'am.
Have you ever received any type of treatment for mental health issues?
No, ma'am.
Have you ever been on type of any mental health medications?
No, ma'am.
All right. Any other questions, defense?
No, Your Honor.
Okay. So state you're presenting to the court for review the police report?
We are, Your Honor. It's a prosecution guide. And the state would also note that the defendant does have. I apologize, Your Honor. Odyssey is giving me a little bit of trouble. Just the open theft case as criminal history.
Okay. All right. Here, state.
Thank you, Judge.
All right, this is what the court is going to do. The court is going to set your bond at $60,000. There's to be full GPS, waive fees. There's to be no contact and no residing with minors. This is what I can tell you, counsel. If he's employed and if he provides proof of employment to the court, then the court can always consider lifting the full GPS.
Thank you, Your Honor.
Is there anything else with regards to the bond? Any other conditions that are being requested by either party?
Just no contact with other minors, Your Honor.
Yes, I said no contact with minors.
Yes, Judge.
Oh, no problem.
Not from the defense, Judge. Thank you.
And Mr. Insariaga,
Yes, ma'am.
I want you to know that I understand when I say no contact with minors, that means no residing with minors as well. But so there's no confusion, I always have to put it in both places. Otherwise, the court may receive an email from pretrial services saying, well, you know, the minor doesn't have contact with him because the minor is on the property or something of that nature. You're just on the property living in the back. So you can understand you're not to reside in any household where there are minors. So I know sometimes people will have a home and they have a guest home. If there's a minor who lives in that home and you're living in the back, you're not allowed to reside at that location. Do you understand?
No.
Is there anything about my ruling that you don't understand? All right. So where are we on discovery?
Judge, I was just appointed to this case on July 14th.
Okay.
So I haven't received discovery yet. I haven't conferred with the state yet.
All right, Ms. Ferguson, if I can get a reset date for 45 days for discovery, please.
I guess should be fine, Judge.
All right, so which do you prefer?
Assuming the 8th.
All right, don't make us make that decision. All right, September 8th. All right, is there anything else?
Not from the state, Judge.
All right, thank you.
Thank you.
You're welcome.
Yeah, like.
Wilfredo Mati.
Morning, Your Honor.
Good morning. All right, this isn't the, is this?
This is the same case that we had on Friday.
All right.
I recapitulate a little bit what happened. Yeah,
Sure.
he got probation on clause number 2025 CR 002719. After he had pled, but before he was sentenced, they filed an indictment, which was coming out of the same fact pattern, theft case, which is 2025 CR 007197. So I've conferred, and I believe that they are willing to TIC that case if they could add conditions to his probation for any possible restitution that would have arisen out of that case.
Okay. So let me pull up the other case. And that's 2025 CR 0027.
002719. That's the one that he pled on, that you gave him probation. No, excuse me.
That's this case.
Yeah, 7197. That's the one that was indicted. He's before the court. The one he got probation on was 2719.
All right. So what are you all requesting?
If the state had known about this case, everything would have been resolved. So in order to move forward with the TIC, have probationer go on probation, which is what the court parties were wanting, we would want to amend and alter conditions to reflect what would have been done at that hearing had we known about this case. And so if we're able to add conditions to the case for which probationer was granted probation that reflect items for this theft case we want a TIC, then we would be able to resolve everything today.
Okay. Yaya, can you have them bring out this file for me? 2025 CR 002719. All right. So do you understand what's happening?
Yes, ma'am.
And are you in agreement to that?
Yes.
All right. We'll go on the record. The court is, and Ms. Abrams, this is a motion to revoke. Well, not a motion to revoke. It's an amendment of his probation. It is Wilfredo Mati, Mattei. All right, the court is calling 2025 CR 002719 State versus Wilfredo Mati. Can I have parties announce?
Duffy Pitlock for the state of Texas, Your Honor.
Brian Kimbrough for Mr. Mattei.
And are you Mr. Mattei?
Yes, ma'am.
All right, and I'm so sorry, I forget. Is it Mattei or Mattei?
Okay.
Mattei. All right. Mr. Mattei, you're currently on probation out of this court, and both parties off the record have informed the court that this new case appeared. It's 2025 CR 007197. And both parties have agreed that the state would take this case into consideration and add conditions to your probation and cause number 2025 CR 002719 to include any restitution amount that's owed to the complainant and 2025 CR 007-197. And the complainant in that case would be U-Haul. Did you understand?
Yes, Your Honor.
And is that the agreement from the state and the defense?
In addition to restitution, the state would be asking for no contact.
All right. And also no contact with U-Haul.
Is that every U-Haul
Yes,
in America or in Texas?
that's every U-Haul. So you're going to have to do it the way we did before there was a U-Haul. You call your friends, you see who has a truck, right? And that's what we would do in the past.
No U-Hauls.
Okay. All right. So is that the defense and states agreement?
Yes, Your
It
Honor.
is, Your Honor.
All right, Mr. Matei, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Wilfredo Matei.
All right, Mr. Matei, did you understand the agreement that's been reached between yourself and the state?
Your Honor.
And are you in agreement to that?
Yes.
And you understand in cause number 2025 CR 007-197, you have a right to a jury trial if you so wish?
Yes, Your Honor.
And do you wish to have a jury trial in that case or no?
No.
All right. So then the court will accept the dismissal from the state without objection.
No objection.
And as previously stated, your conditions and cause number 2025 CR 002719 will be altered and amended to include restitution, if any, to U-Haul, and cause number 2025 CR 007197, and there's to be no contact with U-Haul. Is there anything else from either side?
Nothing further, Your Honor.
Not from the state, but if the state may tender.
Thank you. And probation will go over your conditions with you. And we're off the record. Counsel, do you need a setting for a restitution hearing with regards to that? All right, thank you.
Thank you.
Thank you.
Oh, it's 2025 CR 007197. Oh, I'm about, just give me 1 second because I'm about to give it to them. All right, so who is here on Raul Fernandez? Oh,
Your Honor.
Yeah, that's the one that is on probation. Yeah, I mean.
Yep.
Are y'all ready to proceed on the motion?
We are ready.
Court is calling 2021 CR 11807 State versus Raul Jacob Fernandez III. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Peter Calderola standing in for Gail Calderola for Mr. Fernandez, Your Honor.
Are you Mr. Fernandez?
Yes, ma'am.
Do you have any objections to this attorney standing in?
Just made a mistake and no.
I mean, if you have.
No, man, no, man, no, man.
All right. Did you review the motion to revoke community supervision and state's motion to supplement pending motion to revoke probation with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Raul Jacob Fernandez III, guys, we're on the record, who was placed on community supervision in 2021 CR 11807 for the offense of possession of controlled substance penalty group 1 gram to 4 grams on February 15, 2022 for a term of 4 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bexar County, Texas, the defendant Raul Jacob Fernandez III did then and there fail to report to the supervision officer as directed for the months of March through December 2022 in violation of condition number 4.
All right, to that, how do you plead? True or not true?
The state will waive and abandon the remaining violations, Your Honor.
No objection, Your Honor.
All right, did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 4 years in the prison?
Yes, ma'am.
And up to $1,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
No.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Your Honor, we don't have an agreement, but we have proposals.
All right, state, what are you requesting?
We are requesting that you grant the state's motion, revoke probationer, sentence probationer. The state recognizes you have 4 years. State is asking for 3. The state will tender TICs for 2 new number 1s at the resolution of this matter.
And Judge, that we're following that proposal.
Oh, you all in agreement to the 3 years?
Yes.
Yes, Judge.
All right, sir, are you waiving your right to appeal?
Yes, ma'am.
And are you asking the court to follow this agreement?
Yes, ma'am.
And what cases are being taken in consideration?
Possession of a controlled substance.
The cost numbers.
Oh, sorry, Your Honor.
Okay.
Yes, we have 2025 PF 23502. And the second one, 2025 PF 23503.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed. Oh, I'm so sorry. Just one moment. The court is going to grant the motion, find violation of condition number 4 true, revoke, sentence you to 3 years in the prison, give you credit for any time served, take in consideration 2025 PF 23502, 2025 PF 23503, and the court will request the therapeutic community. All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. So why were you not successful?
I just messed up, ma'am. Sorry.
No, I understand that sometimes things happen, right?
No.
So here's the thing. It appears to the court that you may have a drug issue. You need to make sure that you take care of that. You'll request the therapeutic community. I have no jurisdiction to have them force you into the program or order them for you to be in the program. But if you don't ask for it, they definitely will not put you on the program. Once you're released from prison, if you can't find a sober support home or somewhere to stay or help with your addiction, you can come back to court. If I'm still here, I get you the help. You understand?
Yes, ma'am. Thank you.
Because the last time you use may be the last time you use, and only 2 things are going to end up happening in your situation. Either you're going to end up in and out of prison or in and out of jail, or either it may be the last time you use. You understand?
Yes, ma'am.
All right. Good luck to you, sir.
Thank you.
You're welcome.
Thank you, Judge. Are you excused?
Yes.
Judge, if we may tender the 2 dismisses to the court.
Yes.
Then we'll give you a copy. That was an agreement.
Thank you,
Thank you.
Judge.
All right, who's here on Ricardo Salas? Oh, that's already been set. Let me just double check. Who's here on Christopher Shaw?
Christina Shaw.
Christina Shaw?
Yes,
All right, thank you.
Shaw, come on in. Folders up here. Wait.
Hello. Hi. All right, the court is calling 2025 CR 007106 State versus Christina Louise Shaw. Is that how you pronounce your last name?
Yeah.
All right. That party's announced.
Duffy Pitlock for the state of Texas, Your Honor.
Jay Moritz, Your Honor, from the Shaw.
And are you Ms. Shaw?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Shaw, did you review the indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Shaw, did you review the court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
I'm sorry, is the court admonishments
It's this document. It tells you everything, what you're charged with, and it tells you the range of punishment, and it tells you what your rights are.
Okay.
Did you review that with him?
Yes.
And did you understand it?
Yes.
And did you sign it in all the appropriate places?
Yes.
All right, so you're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from a $10,000 fine and anywhere from 180 days up to 2 years in the state jail facility. If you have a plea with your attorney and with the state, the court does not have to follow that agreement. If for any reason the court does not follow that agreement and give you more than you bargained for, the fact that you entered a plea will not be used against you, and we can start over. Do you understand?
Mm-hmm.
And you can withdraw your plea. Do you understand?
Yeah.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that?
Yes.
Did you understand by entering this agreement you're giving up those rights?
You understand that you're given the rights to a trial by jury?
Yeah.
All right, so I'm going to take it step by step. Okay. And has she been before me before? Why do I remember her?
No, the first time she had some cases years ago where she was ruled incompetent.
Okay. All right, so you have a right to a jury trial. Do you understand?
Yes.
All right, so what that means is 12 people would sit on a jury. 12 people neither you or the state knew beforehand. And the state would call witnesses. Do you understand?
Mm-hmm.
You're going to have to say yes or no.
Okay.
Right. And the state would call their witnesses, and then your attorney would be able to ask them questions, or you could ask them questions. Do you understand?
Yes.
All right. So because you're entering this plea bargain agreement, the state is not going to call any witnesses, and your attorney is not going to have a chance to question any witnesses, and you won't be able to question any witnesses. Do you understand?
Yes.
All right. Do you understand that if the state were to call witnesses, the state couldn't say, I'm going to call Ms. Schott as a witness. So do you understand that?
Yes.
So you're giving up your right to remain silent also by entering into this plea bargain agreement that you've reached. Do you understand?
Yes.
So do you want a jury trial? Yes or no?
No.
All right. Counsel, has your client been able to provide you with any defenses?
Yes, Judge, I've had a Zoom with her at the jail and we discussed things.
Do you believe she has a rational, a factual understanding of the charges against her?
In my opinion, at this time, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Judge.
Ms. Schott, has anyone threatened you, forced you, or coerced you to get you to enter this plea?
No.
Anyone promised you anything other than the plea bargain agreement that you've worked out?
No.
Are you satisfied with the way you've been represented?
Yeah.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
All right, so this is what I'm being told your plea bargain agreement is. It's 180 days in the state jail facility. You're not applying for any type of probation. And there's to be $60 to be paid to the Bexar County Laboratory. Did you understand that?
Yes.
And that $60 is what they say it costs for them to do the drug testing. Did you understand that to be your plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, it is, Judge.
Did you review the waiver of appeal paragraph with your attorney?
Yes.
Did you sign it in both places?
Yes.
All right. So by signing that, if I follow this plea bargain agreement, you can't come back later and appeal that. Do you understand?
Yes.
The only rights you have to appeal is if your attorney has filed pretrial motions, such like maybe a motion to suppress or something like that. And I've made a ruling on that. Do you understand?
Yes.
Counsel, have there been any motions that you filed where the court has made a ruling on them?
No, Your Honor.
All right. Then to the charge, how are you going to plead? Guilty, not guilty, or no contest?
No contest.
All right. State, any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
All right, State, you may be excused.
Thank you, Judge.
No objections, Your Honor.
Thank you. All right, did you review the stipulations and waivers with your attorney? That is, it consists of police reports, the reports from the chemist on whether or not the drugs tested positive for any type of drug. Did you review those documents with your attorney?
Yes. Yes.
All right. So I just want to make sure you understand the state is presenting their evidence now by not calling witnesses. They're just bringing in police reports for the court. Do you understand?
Yes.
Now, if you want to, you can force the state to bring in witnesses to say that you committed this offense beyond a reasonable doubt. Do you understand?
Yes.
So do you want them to present witnesses or no?
Yes.
All right. Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Yes.
All right, anything you wish to say on behalf of your client?
No, Judge, we've gone over this, and at the time of the incident, it appears that she was under the influence of narcotics. And I've conferred with her and believe that she understands everything that she did, and her competency is intact right now.
All right, the court is going to sentence you to 180 days in the state jail facility, give you credit for any time served. The court will request the therapeutic community. There's to be no contact with the Valero located at 12111 O'Connor Road, San Antonio, Texas, 78233. And there's to be restitution to the Bexar County Laboratory for drugs testing. in the amount of $60. Is there anything else with regards to sentencing?
No, Judge, yes, she's been in custody since 4/16/25. We're asking if she would, she gets, or if you get the paperwork from the state jail facility to allow the 80/20 credit.
All right, what will end up happening is that's going to depend on any programs that you're participating in. If you're participating in the programs and internalizing everything, I will strongly consider giving that to you. So whether you receive that or not will be completely up to you and your actions. Do you understand? Yes or no?
Yes.
Okay. Did you review the trial court certification of defendant's rights to appeal with your attorney?
The one you signed?
Yes.
That's right.
All right, because you entered into a plea bargain agreement, and because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. So here's the thing, Ms. Shaw. It appears to the court that you have a drug problem, right? When you are released from custody, if you cannot find a place, be it a sober living house, or if you have a problem with your sobriety and you just need some extra help with it, if I'm still here, you can come back here and I'll pick up the phone and find a place for you, okay?
Okay.
So only one or two things can end up happening if you continue on this path. Either you're going to end up in and out of somebody's jail or prison, or either somebody's going to have to identify your body. You understand?
Okay.
And I don't want that for you, okay? All right, good luck to you.
Thank you.
You're welcome.
Good luck.
Ms. Shaw?
Who's here on Maximiliano Rosales?
Would you honor?
Page is on. Just give me a moment.
Sam.
So this is motion for early termination?
Yes, Your Honor.
All right. And state, are you opposed to the early termination?
The state is not opposed, Your Honor.
Oh, okay.
Always a bonus.
Yes.
I have checked in with your probation officer and I'll let her speak for herself.
Yes.
Judge, I did check in with the CSO and he says that the probationer has been doing great. He feels like he has been rehabilitated. He has not had any compliance issues and he's in support of the early termination.
All righty.
Yeah.
So here's the $1 million question. What have you learned?
Not to be causing mischief and corruption, not doing drugs, trying to work better with my record is difficult to get a job. I've been doing temp services and but yeah, being productive citizen, that's what I've learned.
All right. So this is what I'm going to do. I'm going to follow your agreement and probation. If you can contact Deanna, they usually have specific places that will hire people who have criminal history. And so make sure you contact them. If you contact them, they'll probably be able to have a job for you probably by the beginning of next month. Okay. But here's the thing. I always tell people wanted to be president of the company. You got to start somewhere, right?
Yes, ma'am.
So the key for you is, let me just get a job to support myself, and you can still keep looking for other things.
Would it be possible to get it off of my record?
Oh, you'll have to speak to your attorney about that.
All right.
All right. Good luck to you. Congratulations.
Yes.
Thanks for turning your life around.
Thank you. I appreciate you. Thank you.
All right. You're welcome.
Thank you, Judge.
Right, thank you. Yes. Well, wait till he gets the information so that we can make sure he has employment.
Yes, ma'am. Thank you very much, Your Honor.
You're welcome.
Or I didn't know if you were coming. Where are you going?
All right. Who is here on Joseph Grosso?
I am, Your Honor. I have focus.
Yes.
Judge, I conferred briefly with Duffy that Your Honor, was set for trial next week. Judge, Mr. Grosso is still incompetent to stand trial.
Okay.
We have a status conference. I looked at my calendar in the magistrate court on December 15th, Judge. So it's still out there pending.
All right. So what I can tell you is, depending on what medications they started him on, he may never regain competency. So
it's likely that might happen. I'll be upfront with the board. Yeah.
So is there any objections then to setting this in late January?
No, Judge. None from the state.
All right. Ms. Ferguson, if you'll recall this late January, please.
That's fine.
All right, thank you.
Thank you, Judge. Maybe excuse.
Yes.
Thank you.
And Norma, that date needs to be a phantom date because I don't want it to interfere with whatever treatment he's receiving. Yes. Thank you. And on what page is Grosso on the docket? Okay. Yeah. All right, so where is Mr. Saganya?
I'm here, Judge.
Oh, okay. All right, thank you. I'll let you continue. You're welcome. Thank you. All right, who's here on Tiffany Martinez? And after Tiffany Martinez, it will be Valdemaro Chapa.
Here, Mr. Chapa, Your Honor.
Oh, that'll be after Ms. Martinez. Hello, good morning. One moment.
Thank you, Judge.
You're welcome. And this is your first setting?
No, we've been
No,
here
it's not.
a
Okay.
few times, Judge. We are here on a setting where the state has given a new offer that we'd like 30 days if the court will give us time to consider this new offer, which is significantly better.
All right, I tell you what, I'll give you 3 weeks because we were actually scheduled for jury trial, and the day is for us to obtain a new jury trial date. So really recall that's back in 3 weeks. That will be your final plea deadline date.
Understood, Judge.
All right, Ms. Ferguson.
Yes.
I need a 3-week reset for a plea deadline date, and this is the final plea deadline date. All right, once you sign the reset form, you are excused. What page is she on? Thank you. Baldomaro. All right, so we need a jury trial date.
Yes, ma'am. And Mr. Chapa is here to present himself to this court. He did miss court last week. We were vocal with him through that process. He had some car trouble that day. If Your Honor will look at the case file, he has not missed it. We have not had any issues out of
Right,
him.
so here's the thing. He'll need to go in custody. And if you want to call the bondsman.
The bondsman is here and he is willing to remain on the bond, Your Honor.
All right, where's the bondsman?
Amanda, you might just step right out.
All right. The document I have from the bondsman is a motion to increase bond.
Fernando is the bondsman, Your Honor.
All right.
I know him.
Oh, great. I'm familiar with the Birmingham Black Barons from days of old, from history. All right. So with this case, I received a motion for a request for a bond increase. You're no longer requesting that.
No.
All right.
And I have a motion for the reinstatement bond if I have to.
All right.
But I'm willing to stay on this bond.
All right. So state the court is looking at the docket sheet. He's always been here. Do you have any objection to the bond remaining the same?
We do, Your Honor. He was set for trial and failed to appear at that trial date, and presented a flight risk to this court and to the state, showing the court that when it's time to go to trial, he's not going to be here. And so for that reason, the state would request that he be remanded without bond. And if the court was inclined to set a bond, then the state would ask for $200,000, which would be, I believe, $115,000 more than his original bond.
All right. So we're going to go on the record, and Mr. Roper, I'll note that you have no objection to the bond being reinstated. So let's see what happens with this hearing.
Yes, ma'am.
All right. Thank you.
Thank you.
Court is calling 2024 CR 009634. State versus Baldomaro, Joseph Chapa. Can I have parties announced?
Ashley Jones for the state.
Dante Dominguez for Mr. Chapa.
And are you Mr. Chapa?
Yes, ma'am.
All right. So state defense hasn't filed a motion for reinstatement of the bond, but the court will note for the record that the bondsman has presented the court with a document asking that bond be reinstated. And it's the court's understanding, state, you're in objection?
We are, Your Honor. The state just would like the court to note that the case was set for trial, and at that trial date, this defendant failed to appear, showing the court that he has no intention of appearing when it's actually set for trial. And so for that reason, the state would request that the defendant be remanded without bond. And if the court is inclined to set a bond amount, the state would recommend $200,000 and full house arrest GPS.
All right. So yes, if you'll address the issue of him not appearing.
Yes, ma'am. It was last week. I believe it was last Wednesday, or it might have been Tuesday, but he did not appear. It was a car issue. He did attempt to come to court on Thursday. I was vocal with him that day. As Your Honor will remember, I believe you were in trial on that day. And your clerk said that Monday morning would be the best opportunity to be able to flesh this out with the short hearing that we're doing now. So that was my suggestion to him, and he did make himself available that day. I have also consistently been speaking to his bonds person who the court has heard from this morning as well. He is going to stay on it. Now, I have not had a problem contacting Mr. Chapa through the tendency of this case, and this is the first time he's ever raised a court date.
So why didn't he appear? I understand the state's argument that it was scheduled for jury trial. So the question is, if he had car problems, then why didn't he still appear later?
We do not have a good answer for that, Your Honor. He missed court, and we can't make him be here for it.
It was a bad day. My steering wheel got like locked. I broke my key trying to unlock it. My phone died. I didn't have no way to charge it. I started walking, try to get to a phone so I could call my mom. My mom actually had already left to come here, because if not, she would have gave me a ride and I would have been here. It was just one of those horrible things. You know, I've never missed anything when it comes to court, ma'am. I always show up. I'm always proper. I've never had any problem.
And I can tell the court that his mother was here on that court date, Your Honor.
No, I remember his mother was present, but she's not scheduled for trial.
Yes, ma'am.
All right. This is what the court is going to do. The court is noting that the defendant has appeared for every setting besides that specific setting. And he has been scheduled for jury trial more than once, and he's appeared when that jury trial was set. Sometimes there's a lot that happens and it hits somebody all at once, and the court is understanding of that. The court will reinstate the bond. The bondsman has agreed to have the bond reinstated. The court is going to give you all a jury trial date if you'll confer with the state, and that will be your jury trial date. This is what I want to stress to you. And we can go off the record. There are not to be any other things piling on top of each other where you don't make it for court. You have to have backup plans. I understand when a steering wheel gets locked. That has happened to me before, and guess what? It's not unlocking. All right. So he can be released. I'm going to sign the motion to reinstate the bond. Yes, recall the warrant. And bondsman, if you'll give me the documents for the reinstatement of the bond, please. And if you all confer with Ms. Ferguson on a jury trial date for dressing appropriately for court, just have a seat.
Thank you very much, Your Honor. And once you get that date, maybe you see us.
Oh, you'll have to tell me what the date is.
Yes, ma'am.
Thank you.
Thank you, sir.
Oh, thank you.
All right.
Thank you,
The
Judge.
clerk receives that.
Okay. Thank you.
All right, thank you. So do we have a jury trial date? Don't go past September. Right, thank you. Yes.
September 22nd.
All right, September 22nd.
Thank you, Your Honor. Here, Longoria.
All right, who is, yes. Mr. Woodard, if you come forward, please. All right, Mr. Woodard, your attorney had a medical emergency in his family. So he's asking that you be recalled for the 24th. We're going to put you for the 24th, but it really depends on if he is prepared to come back. Do you understand?
Okay, that's 24, right. 3 days?
Yes.
Okay.
All right, the 24th.
Thank you.
You're welcome. Deputy Laura, what page is Woodard on? I found it. It's sort of like Marco Polo, right? Found it. Who's here on Juan Cruz? Right. All right, so in this case, we're here for discovery. Where are we on the discovery issues? Home surveillance from complaining witnesses' phone.
Your Honor, we did speak with the complaining witness's family on Friday, and we are in the process of getting that information. We did get other recordings that we provided to defense this morning, and counseling methods we have received, and they're just in the process of being uploaded. We just need a little bit more time for the home surveillance.
And then was it that the counseling records were sent in under pending transmittal?
Oh, yes, Your Honor. So we've received them. They're just waiting for a paralegal to upload.
Okay, so the only thing that's outstanding is the home surveillance?
Yes, Your Honor.
And I did want to add an ethical disclosure regarding a potential witness.
And I'm sorry, what else?
An ethical disclosure regarding a potential witness.
All right. All right, how long is it going to take you all to have that?
Your Honor, it shouldn't take very long at all. If the complainant witness mother has it, she'll send it over to us. And the state is prepared to make an offer, or has made an offer to defense.
All right, Ms. Ferguson.
Yes, sir.
3 weeks for a final discovery, please. Is that good for you, counsel?
Yes, I believe so.
All right, so August 11th. Is there anything else?
Not from the state judge.
All right, thank you.
Thank you.
Thank you.
May we be excused?
Yes. Yes. Yes.
Which way you go? Which way? We'll see. We can get that.
Lynn Wayne Morin.
President Reed.
Thank you. And there's no application?
There's none, Judge. It says it's cap offer.
All right. And are you going to ask for, do you need a PSI and tap, or do you just need a reset for?
I like a PSI, Judge.
All right. What date for a PSI? And is there going to be any mental health, a MIC evaluation or no?
I don't anticipate that, but I will have a witness to that effect.
All right. All right. Ms. Abrams, this is going to be September 15th for a PSI. Court is calling 2025 CR 001248, State versus Lynn Wayne Morin. Can I have parties announced?
Samantha Lynn Brown for the state.
Louis Martinez on behalf of Mr. Morin.
And are you Mr. Morin?
Yes, yes.
Counsel, have you received all discovery? Did you review that with your client?
Yes, Your Honor. The discovery that I could review with him, I reviewed with him.
Court will find that the state is in compliance with discovery. Mr. Morin, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Morin, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right. You're charged with possession of child pornography with a child younger than 10 years of age. As a first-degree felony, the range of punishment is anywhere from 15 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, Your Honor.
By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Just one moment off the record. Yaya, can you make sure these are file stamped so that the defense can have their motions to seal?
Yes. Yes.
We're back on the record. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor, yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Morin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
That's your copy.
Thank you, Your Honor. You're welcome.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to your plea, your punishment is to be assessed at a cap of 30 years in the prison. There's a $5,000 fine. There are no applications in Chapter 62 compliance. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
State offers State's Exhibit 1 and all attachments and State's Exhibit 2 and its contents. And at the same time, I would move for that motion to seal to be signed for the contents of State's Exhibit 2, which contains the child pornography images in this case.
That's all without objection, Judge.
All right. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Did you understand that there are certain documents that contain child pornography that your attorney and the state have agreed that that would be sealed?
Yes, Your Honor.
And did you understand that in order for it to be unsealed, someone, an attorney or a party, would have to file a motion and have a hearing, and the court will make a ruling on whether or not to unseal that?
Yes, Your Honor.
So after today, do you understand that that document or those documents will be sealed, and those documents will not be accessible to the court or to the state or to the defense or to you? Do you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. This will be set for sentencing on September 15th. Once you sign the reset form, you will be excused. And if you'll talk with probation, they will do what's called a PSI investigation. It's not for purposes of probation. It is merely for me to obtain more information about you. Do you understand?
Sure.
All right, thank you.
And Judge, just
Yes.
really quick, did you admit State's Exhibit 2 as well, which is the sealed?
Yes.
Okay, perfect. Just want to make
Thank
sure.
you.
Thank you, Judge.
All right, thank you. No, just a PSI.
Thank you, Judge. May I have your please?
Yes. Louis, if you want, I can see if that PSI can be expedited so we can hear it sooner. All right, thank you.
Well, if you want some stuff.
Is there someone here with an interpreter?
Yeah, that would be Joseph Stateson.
And where is he ready or no?
I'm finishing the paperwork now, Your Honor.
All right. Maverick Dennis Ennis. Court is calling 2025 CR 0022989, State versus Maverick Dennis Ennis. Can I have parties announced?
Deputy Pitlock for the state of Texas, Your Honor.
John Robertson for Mr. Ennis.
And probation, this is an application. All right. Are you Mr. Ennis?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Ennis, did you review the application for community supervision with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Ennis, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with the offense of criminal mischief, $2,500 to $30,000. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call them the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am. I fully understand.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Ennis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am. Under no circumstance.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Fully.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. The state recommends community supervision. They're taking in consideration 2025 PF 12413, 2025 PF 12414. There's to be restitution to Cornelius Meister, Meister, Marlene, Marlene, Pollard, Pollard, and 2025 PF 12414. There's to be MRT, no contact with the complainants, tap evaluation, and follow all recommendations. Did you understand that to be the plea?
Yes, ma'am. I fully do.
Defense?
Yes, sir.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am. I fully did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, no.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There'll be a TAP evaluation, 100 hours of community service restitution, and no contact with the complaining witnesses. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
Yeah, no more fouls, please. All right, I'll pick it up after lunch. All right, state, any evidence to support the defendant's plea?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objection.
All right, did you review the waiving stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am. I fully understood.
Again, did you understand you have a right to jury trial and the right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
All right. So it says damage to a vehicle, $3,609.22. Are you all agreed to that amount or no?
It appears that's an accurate amount. There's an estimate in the STIPS, Judge.
Okay.
And it was some body damage in a window. And the way the body repair business is now, it's no small damages that I'm aware of.
All right. So that amount goes to Cornelius Meister, $3,609.22 restitution to Cornelius Meister. I don't see the restitution amount for Marlene Pollard. Do you have a restitution amount?
Your Honor, those are for the TIC cases.
Okay.
I think it's going to be less than $100, Judge.
All right. So, Mr. Ennis, it appears that you have a problem. What is your problem?
I made a mistake. I was going through like a life change. My mother, my child had left me, so I just started making irrational and
I mean, sometimes people leave people for good reasons. I don't understand how that equates to your
I was
being abusive to a dog.
that, that it wasn't that half the statements is not true. Just I had somebody that had in my life that wasn't the best for me, and then they was doing anything to hinder me. But I'm not trying to minimize or justify my negative behaviors. I just made a crucial mistake in my life, and I'm
no crucial choices.
Yes, ma'am.
So here's my question. They say that how this all started is that it states, victim states he was waiting in the parking lot of the listed location for his friends, just minding his business, waiting for his friends. Victim states he saw a suspect, that's you, chasing after a dog and beating it.
And those some of the things are not accurate, but
well, is that accurate?
I never touched the dog. I was maybe yelling at my dog trying to get it back in the house, but I'm not like once again I don't want to minimize justify my negative behavior. So
well, I'm going to tell you right now, I'm not going to allow you to have any animals. I don't know why people want to get dogs, get pets. They don't get them their shots. They just keep them chained outside and like, here's some water and some food. Now, there are different standards for dog treatment. Number one, they have to have their vet bills and they need to get seen by a veterinarian on a regular. And if you can't do that, that means that you can't afford an animal and you shouldn't have one.
yes, ma'am. I haven't had one.
I'm sorry?
I'm so sorry to interrupt you. I haven't had one since.
Well, I will not allow you to have any pets, not even a goldfish.
Yes, ma'am.
Do you understand? Or those hermit crabs that they're so fond of giving away at the fairs. You are not to have a living, breathing, any type of pet.
Yes, ma'am.
The bearded dragons, a bird, whatever it may be. If it has a pulse, if it's living, breathing, all creatures great and small, not allowed.
Yes, ma'am.
I'm not going to allow you to have any contact with minors. And let me just tell you why. Because this is concerning to me that you were beating a dog. Now, I will order parenting classes because you're saying you have a child.
Yes, ma'am.
And once he completes parenting classes, then I'll consider lifting that.
Yes, ma'am.
When's the last time you had employment?
I was currently employed prior to me being here.
Doing what?
Lawn care.
All right. And how many children do you have?
I have 4 kids I have full custody of.
So who are they with now if you have full
My
custody?
significant other.
And is she the biological mother of
Yes,
these
ma'am.
children?
Yes, ma'am.
All right. So I don't know where you're going to be living, but I'm not going to allow you to reside in a home with minors either, because I find this dog issue very concerning.
Yes.
Have you ever had any type of mental health issues?
Yes.
All right. So what has been your previous diagnosis?
I suffer from severe depression and anxiety, and I have insomnia, I have sleep disorder.
All right. And then have you ever used drugs in the past?
Yes, ma'am, but not currently.
And what would those drugs be?
Marijuana.
All right. So as previously stated, the court is finding him guilty. The court is going to sentence him to 2 years in the state jail facility, suspended and probated for 4 years. Taking consideration 2025 PF 12413, 2025 PF 12414. There is to be restitution of $3,609.22 to Cornelius Meister. There's to be restitution, if any, to Marlene Pollard. And cause number 2025 PF 12414. There is to be a TAP evaluation and MIC evaluation in custody. Follow recommendations. There's to be no contact with minors. There's to be no residing with minors. There's to be no contact with animals.
Yes, ma'am.
And for the court, an animal is all creatures great and small. You can't do a mouse, you can't do Michael Jackson, Ben, none of that. You understand?
Yes, ma'am.
So no contact or ownership of any animals. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. No employment as a home health care provider or with minors. 100 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Probation, I'm sorry, I'm going to need field visits 2 times per month until further notice. And if you could have somebody please go to that house, check on the children that are in that house and make sure everything is safe with them. Is there anything else, probation?
No, sorry.
Is there anything else you need from the?
Are they Pollard?
Pollard, Pollard. Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, you're gonna have to do better and we're off the record, find your empathy, sympathy bone and put it at the forefront of your life. You understand?
Yes, ma'am.
All right, good luck to you.
He also had a family violence assault, Your Honor.
Okay. All right, just 1 second. I'm sorry, Mr. Pollard, come back. So who is the complainant in the assault family case?
Her name is. Might be mispronounced again, Montisha Nicholson.
Can you spell the first name?
Monteysa, and then Nicholson of Mississippi.
All right, we're back on the record and cause number 2025 CR 002989. And there's also to be no contact with Monteysa, Monteysa Nicholson. And the court will take in consideration 2025 PF 22670.
Yes, ma'am.
Thank you. DeMonte LaRoberts Williams.
If you're reaching back with the Michael Jackson, Ben.
Huh?
We're reaching back.
Hey, Ben, the two of us need look no more. We both found what we've been looking for. Hello, come forward. All right, State, on this case, do you have all the discovery?
So, Judge, we do. The issue is we've got an unindicted case that's of a substantially higher degree of offense that has not been indicted.
And what case is this? What's
an ag assault, Judge?
All right, State. I'm going to recall this in 30 days. Y'all need to let me know what's happening with the other case, if it's going to be presented or not.
Yes, Judge.
All right, Ms. Ferguson, on Robert Williams, if I can have a 30-day reset for discovery. And you need to make sure you're on time for court. Court is at 9 a.m. You understand?
Yes, ma'am.
All right. All right, we'll bring you back on August 19th. Once you sign the reset form, you are excused.
Thank you, Judge.
Thank you. Roman Flores. Oh. All right, how's it going? Oh, and you dated it too.
Of course.
Thank you. Thank you.
Thank you, Judge. Have a good day. You too.
All right, so today is Discovery Day.
Yes, Your Honor, I have all discovery in the case. There is an offer that's been made by the state. We're requesting that the court set a plea deadline.
All right, sir, how old are you?
30 years old.
All right, Ms. Ferguson, if I can have a 2-week reset for plea deadline date, please. And it's Roman Allen Flores. All right, August 4th.
Thank you, Your Honor. Okay. See you.
All right, everyone else, the court is going to go on recess. Okay, bring Mount Council up.
I just need to let the court know that I filed a motion for insanity.
All right, so I'll have to take that up at after recess.
Which has to be brought up again,
No, Mount Council.
Yes, that's the one.
Oh, then it's not a, why is it set for a plea if it's for Saturday?
I don't know what.
All right.
So it's been filed.
All right, Mount Council, what date? Have you already filed the Saturday?
I have filed it.
Yes.
I've been in jail in June. I haven't been in court yet.
Oh, Miss, you were in court on June 24th.
I broke my house. I'm in bad shape. I can't even get out of bed. I can't even go to the bathroom. And they won't give me some supplies. They're trying to give me some supplies for that means.
All right. Well, Miss,
it's prescribed in my home.
All right, Miss Mount Council, you were scheduled for court on June 24th, but your attorney was in jury trial in Comal County. And then we brought you back for July 7th. And I believe we had that by Zoom. And so now you're here today. Ms. Ferguson, set it for 45 days. They should have the sanity evaluation completed by then. All right, September 8th.
Help. I'm nearly embarrassed when I'm in such bad shape where I stink also.
All right, no problem.
And I can't, I'm not that way. I'm a friendly person.
All right, thank you.
Thank you, Judge.